Today's topic is frustration. Frustration is a legal doctrine that a party can rely upon to terminate the contract in certain circumstances. If performance of the contract becomes impossible or illegal or something different to what the parties had in mind when they made the contract due to an unforeseen event that takes place after the date of the contract, which is beyond the control of the parties and for which the contract does not provide. Therefore, frustration arises when there are unforeseen events which occurs after the contract has been concluded and cannot form the basis of a claim for relief on the grounds of mistake. However, in such a situation, a court may hold the contract has been discharged by operation of the doctrine of frustration. Therefore, courts may discharge the contract. The case that is important for you to revise is Herji Moji versus Chiong. A principle that has been established in this case is that a contract which is discharged on the ground of frustration is brought to an end automatically by the operation of a rule of law, irrespective of the wishes of the parties. Therefore, if the frustration grounds apply, even if any of the parties do not want to terminate the contract should be terminated on the grounds of frustration. One of the grounds in which a frustration can occur is the impossibility of performing the contract. A contract that has become impossible of performance is frustrated. The case about it, a Taylor versus Caldwell. The defendants here granted to the claimants a license to use their hall for concerts at a fee of £100 per concert. After the contract was concluded, but before the first concert was performed, the music hall was accidentally destroyed by fire. However, neither party caused the fire. The claimants argued that the defendants were breach of contract, but the defendants relied on the doctrine of frustration. The court held that the contract was frustrated because the destruction of the music hall made the performance of the contract impossible. There could be frustration of the purpose as well. For example, the event doesn't happen, where the common purpose for which the contract was entered into can no longer be carried out because of some supervening event. The contract may be frustrated. Examples of frustration of purpose are, however, extremely rare. The reason for this is that the courts do not wish to provide an escape route for a party for whom the contract has simply become a bad bargain. So frustration is usually not a way for a party to get out of a bad contract. There has been some essay questions asking similar things, like if frustration could be argued to be a route to escape a bad contract. This short answer is no, but you obviously need to go through all the possible ways of frustration that can happen, such as impossibility, illegality, so on, and have a look at the relevant cases and make arguments for and against if frustration has become, in recent cases, a way to escape the contract or not. Krell versus Henry is another case that you should take into consideration about non-happening of the event. The defendant here decided to hire a flat in Pall Mall from the claimant for 2 days for the coronation of King Edward. The contract between defendant and claimant did not contain any express terms or any other purposes for the flat. However, the king fell ill and the coronation didn't take place. Although the purpose was not written in the contract, the Court of Appeal held that the contract was frustrated. The event didn't take place for which the contract was concluded. Therefore, it has become impossible because of the non-happening of the event. Illegality is another way for the contract to be frustrated, when supervening illegality can operate to frustrate a contract. Fibrosa Spolka is a case that you should remember. Here, the respondents agreed to manufacture machines for the appellants and to deliver them in Poland. However, before the respondents had completed the manufacturing of the machine, it was occupied by the German army. Because of the war, the contract has become frustrated. The court held that the contract was frustrated because in the time of war, it is against the law to trade with the enemy. The public interest in ensuring that no assistance was given to the enemy in time of war outweighed the fact that it remained physically possible to manufacture and deliver the machines. Our advice is, when answering questions on frustration, ensure that all three ways in which a contract can be frustrated are explained. The three ways are impossibility, illegality, and change of circumstances. We have only discussed the cases for impossibility and illegality. We haven't discussed change of circumstances, and we haven't discussed all the cases either. You need to go to our website and have a look at the full notes in order to have the full overview of the topic, and all most of the important cases are there too. Example essay question that you may get on frustration. Frustration is a way to terminate the contract that people no longer wish to continue. Critically analyze. So is frustration a way to just get out of a bad contract? That is basically what the question is asking you. The short answer is no, but you need to analyze all the relevant cases and make arguments for and against. Make sure that your arguments are for both sides, because if you are leaning towards only one side and not making enough arguments for the other side, you will lose points. So the plan should be very clear. Very clear structure will be awarded a high mark. Even if your arguments are really good, but you have arguments all around the place and you do not have a clear structure, your grade will not be high. Make sure that it is a very clear structure. It's very easy to follow your arguments and your flow of writing. And very important is that it has to be very logical. It has to start from introduction, where you're giving definitions. In every essay, in the introduction, you give definitions. It shouldn't be too long, but shouldn't be too short either. Could be around 10% of the total word count. You give definitions of what is frustration, and with relevance to the explain frustration with reference to relevant cases. Then announce what you will be discussing, which is in this case critical analysis of frustration if it is just a way to terminate bad contracts. Main body of the essay should be arguments for and against, and it should be IRAC, right? Issue, rule, application, conclusion. So you need to explain the relevant law and then refer back to the question and make an argument. Everything you say in the essay has to be leading to an argument. Many students write very descriptive essays, and that's how they get low grades. It is not about trying to mention all the cases that you know about frustration. It is about answering the question asked, the strengths of the arguments. If your arguments are convincing and it shows to what extent frustration is a way to get out of a bad contract or not a way to get out of a bad contract, that is how you will be awarded marks. And finally, in the conclusion, you need to sum up your main arguments and answer the question asked. Is frustration a way to get out of that contract? You need to answer that question. I highly recommend you to have a look at our full notes on frustration. We have most of the main cases in there, but I also recommend you to have a look at your lecture slides. Lecture slides in combination with our resources should be the way to go, because your lecture slides may mention some few things that we may not have on the notes and vice versa. So make sure that you use both. Other resources that you can find on our website about contract law is our tutorial videos, our notes, other notes about other topics, example essays, case summaries, flashcards and quizzes, flashcards and quizzes are a great way to practice your knowledge, especially if you have an exam in contract law rather than assignment. Now I'd like to tell you about how we can help at SimpleStudying. At SimpleStudying, the materials that we offer were created by top students and graduates who have all achieved high to one and first class grades in their respective law degrees. And all our resources have been created by the team of top law students and graduates now who have created simple notes, example essays, tutorial videos, quizzes, and flashcards, exam tips for you so that you can achieve high to one and first class grades in the simplest way possible. All our resources focus on what is important for you to know from our own experience to get a high grade in the simplest way possible. That is how we're different from normal revision books or textbooks. We just focus on how to get high grades. If our resources are not enough, and we highly recommend you to get this tutoring sessions, because we have noticed that students who get 6 tutoring sessions or more, they are a lot more likely to get a first class in combination with our study resources. So a lot of students get a first class just with our study resources, but sometimes most of the students still need additional support, just one-to-one support, at least closer to the exams, so that they can get some personalized support as to what they are struggling for overcoming their struggles and making sure that they understand how to write legal analysis, how to answer their questions, how to prepare for exams. It is highly recommended that you have a look at our personalized support tutoring services. We have already helped thousands of law students get high grades. You can see our reviews here that we have helped so many students get a first class in high to one. If you want to be our next student to get high grades, join SimpleStudying now. Thank you for your attention.